This is Bloomberg Law with June Grasso from Bloomberg Radio.
I'll put you each in a room, and I'll ask you every little question that a real couple would know about each other. Step 2, I dig deeper. I look at your phone records. I talk to your neighbors. I interview your coworkers. If your answers don't match up at every point, you will be deported indefinitely, and you, young man, will have committed a felony, punishable by a fine of $250,000 and a stay of 5 years in federal prison.
The proposal is just one of many rom-coms where someone threatened with deportation enters into a sham marriage with a U.S. citizen. The movies usually have happy endings, but a real-life case before the Supreme Court that began nearly 10 years ago still has no ending. The justices ruled unanimously that federal courts can't second-guess the government revoking a visa due to a sham marriage. That's left to the discretion of the Department of Homeland Security, putting the couple back at square one. Joining me is an expert in immigration law and in this movie, The Proposal, Leon Fresco, a partner at Holland & Knight. He was the head of the Office of Immigration Litigation in the Obama administration. So, Leon, tell us about the couple in this case.
So the situation is actually pretty straightforward. There was a U.S. citizen. The U.S. citizen applied for a visa for the spouse to be able to get lawful permanent residence in the United States. The first part of the process, because there's two parts. One is the marriage valid? And then the second is everything fine in the background check? The first part is the marriage valid? That's what's called the visa petition. That was approved. And so they thought, okay, we're all set. Now we're on to the second part, the background check. Everything's going to be good. And then during the background check process, they said, you know what, we're going to revoke the initial approval because we didn't realize at the time that the foreign husband, who they were trying to get the green card for, had actually been involved in a sham marriage where supposedly this guy had paid $5,000 to try to get a green card. And I don't know why USCIS didn't know it initially, but they figured it out the second time around, and so they revoked the petition. They then took an administrative appeal. They lost in the administrative appeal, so they tried to file a federal court case. And the issue in the federal court case is this decision to revoke the initial approval something that you can actually review in the federal court?
So there are mandatory and discretionary decisions. And discretionary decisions can't be reviewed by a court?
Right. There's a lot of things that the government is very concerned that if you start giving judicial review for, there will be thousands, if not hundreds of thousands of federal court cases. So the Congress writes laws that say, here's what we're going to do. We are going to say that in certain situations, the agencies that deal with immigrants will get the final word, meaning sometimes they can be nice, sometimes they can be mean, but whatever they decide, they will get the final word because there's no way we can possibly allow thousands, if not hundreds of thousands of cases to challenge these agencies and what they're saying. There's other times that the statutes say, if you make a decision, you can get review. And so the question is, does a particular statute in any given instance give the final discretionary word to the agency so that you can't review it? Or if the decision is one that has to be made yes or no, and there's no discretion, you either have to decide, for instance, is the person qualified under the visa to do IT work? And so that's either a yes or a no. And if you say yes, that's fine. But if you say no, you can get review of that. I am qualified. I know they said that I'm not, but I am. That's the kind of thing where review is available. But if the Congress says, no, this is a discretionary decision, we want it to be decided by the agency, and they can either be nice or mean, but it's up to them, then they're the last word. You cannot go to federal court.
So why did the Supreme Court here decide that revoking the visa is a discretionary decision?
The statute says if you come across a sham marriage in any part of this process, you can revoke it for good and sufficient cause. But because it says you can revoke and it doesn't say you have to revoke, the Supreme Court said, hey, that's, again, a discretionary decision that either the agency can decide to let it slide, even if there was a sham marriage, or they can decide to revoke the petition. But in either case, That's a discretionary decision. And so because of that, they say that that's then not a decision that the federal courts can review. And that was a 9-0, rare 9-0 Supreme Court decision that was actually written by Justice Jackson, who's considered probably to be the most of the compassionate judges toward immigrants on the court. Even she said that this is the kind of discretionary decision that is not reviewable in this situation.
I thought that sham marriages barred people from remaining in the country legally, that if they found a sham marriage, you were out.
So interestingly, here's how that works. If you apply on step one, so you say, I'm a U.S. citizen, I want to marry a foreign national. You're in step one of the process. If USCIS encounters that there was a sham marriage, either the U.S. citizen had been in a sham marriage in the past or the foreign national had been in a sham marriage in the past, they must deny that petition. And that petition, therefore, can be reviewed in federal court. But this is not how that happened. This was after the fact. USCIS find out that there was an error. Do you have to revoke it? And what the Supreme Court said was, nobody says in this statute that you have to revoke it. You could just let it slide. Now, there's evidence in this case, and Justice Jackson cites to it, that says, well, USCIS never lets it slide. They never are nice to people in this situation. They always revoke every single case where they see that there was a sham marriage involved. But what Justice Jackson says is, who cares? That doesn't matter what they actually do. What matters is whether the legislature gives them the discretion to overlook it or not. And because the language of the statute gives the discretion to the immigration agency to overlook a sham marriage if it is found after the fact, after an approval, not beforehand. But if it is found after the fact, then that's considered a discretionary decision. And so the decision to revoke, which is discretionary, then cannot be reviewed.
This case seems like a wasted effort because if the petition is revoked, the couple can just file a new visa application.
In this marriage context, you can always just apply again. And if they deny you now that they know about this sham marriage, you can get the federal court review you were worried about. And in fact, the plaintiff in this case is literally in the middle of this. So it just seemed like a why are you complaining case at the end of the day, since you actually can get the federal court review that you want by simply putting in a brand new application. And there's no bar in this instance to putting in a brand new application. So that's why I think you end up getting the 9-0 decision, is because in the end, yes, this will close out a way that theoretically could have been available for a revocation of a marriage case. But in the end, what it makes clear is that if you are in this exact situation where your marriage was approved for immigration green card purposes, but now it's been revoked on step 2 when you're going through the background check process, that all you have to do is file step 1 again, and they'll have to deny it because now they know about the sham marriage. And since they have to deny it, that's when you'll be able to get the review of that denial.
So then did this couple actually win the Supreme Court case? Because they're eventually going to get the court review they want.
But she didn't win the case from the standpoint of the relief she actually wanted, which was to immediately be able to get a decision right now as to whether that was really a sham marriage. So she can't get that, and she has to restart the process, like you've said. And so it's a non-ultimate loss, but it's a loss in this forum, in these proceedings, for what she wanted.
Leon, I mean, when the federal court reviews it, they're going to see there was a sham marriage.
Correct.
So the judge will rule against the couple. So what's the point here? Is it just to delay the inevitable?
So sometimes the hope is this, that occasionally what will happen is, so you'll have the USCIS, the Immigration Service, will say that there was a sham marriage, and then you'll have an administrative appeal, but it goes to people who are generally inclined to be deferential to the agency, and so they'll say it was a sham marriage, but you hope you can get a federal court judge who maybe looks a little bit more askance at the government and says, you know what, why are you viewing things in such a skeptical, cynical light? I know there was $5,000 exchanged, but that was for love or something, who knows? And so you get one of these judges who maybe doesn't really trust the government so much, and maybe you can get a decision that's better than you could have ever hoped for. And so that's what they're looking for, is that kind of Hail Mary here in this situation.
What did Justice Jackson mean when she said that Congress created room for mercy in the process?
Well, the mercy that she really meant was that the agency, if they wanted to overlook the sham marriage, they theoretically could have overlooked the sham marriage. So that's the real mercy that she meant. But she also meant that there is this second out here in this particular fact pattern, where in the marriage issue you can go in and you can actually restart and do a new application and then get the federal court review that you want.
I'm curious because there are lots of movies about sham marriages for green card purposes. Are there actually a lot of sham marriages?
So here's what's very interesting is, what is a marriage? And the famous Judge Posner has a decision that really goes into this, which is, talk about movies. One of my favorite ones of this variety is the one with Ryan Reynolds and Sandra Bullock called The Proposal. Yes, where he says at the end, I want to marry you so that I can date you. And the question is, would that be a legitimate purpose for an immigration marriage? Because in the end, you are still professing some sort of love there. And so what Judge Posner said is, this is not exactly the law, but I find it very persuasive, and I keep trying to convince the agencies that this is the real issue, and they're almost there, is this. Did money change hands? Because if money changed hands, that's a sham marriage. But any other kind of marriage, I go to Harvard and my wife goes to Stanford. We love each other, but we don't live together. Non-immigration marriages that are just like that. And so that's where it gets super complicated. And so the issue is, I think, did money change hands? And that really is the main thing they look for. But they also do look, are you living together? And if not, why are you not living together? And, is there constant communication? Is there joint assets? All of these things. And those areas sometimes are not conventional in certain marriages, but they still want to try to enforce those conventions on these immigration marriages.
And that's just what the immigration officer considered in the proposal. Thanks so much, Leon. That's Leon Fresco of Holland and Knight. Coming up next on the Bloomberg Law Show, Marine vet Daniel Petty was acquitted in the subway chokehold death of Jordan Neely. But now he's facing a civil lawsuit. And the case against Luigi Mangione for the shooting death of United Healthcare CEO Brian Thompson. I'm June Grasso, and you're listening to Bloomberg. Both applause and anger erupted in a Manhattan courtroom on Monday when a jury announced its verdict of not guilty in the trial of Daniel Penny for the chokehold death of Jordan Neely on a subway last year. It was a reflection of how the case divided the nation, with some hailing Penny as a hero for trying to subdue a homeless man who was threatening subway riders, while others saw the former Marine as a white vigilante who choked a black man to death. Neely's father cursed in anger when the verdict was announced and had to be removed from the courtroom.
It hurt me to my core, to hear something like that.
But in an interview with Fox, Penny said he would do the same thing again if he faced a similar situation in the future.
I would not be able to live with myself if I didn't do anything in that situation and someone got hurt. I would feel guilty for the rest of my life. And I think I'm in a position, and all people, if they're in a position to help, should always help.
Joining me is Palm Beach County State Attorney Dave Arenberg. Dave, the jury came back last Friday after 4 days of deliberating and said they were deadlocked on the top charge of manslaughter. Over the course of the deliberations, the jury had asked to rewatch the bystander videos of Penny restraining Neely, the officer's body cam videos, and video of Penny's interview with police detectives. They also wanted to rehear the medical examiner's testimony about issuing a death certificate before Neely's full toxicology reports came in. Can you tell from those requests what they were likely hung up on?
It's really the overall narrative, and it was a question whether he acted recklessly, whether he went too far. And even with the lesser charge of negligent homicide, you only need to act carelessly. So they really wanted to know if this guy just went too far, and they wanted to hear from bystanders. They wanted to see video. And by all appearances, it looked like Daniel Penny was a good Samaritan, and he was there to hold Jordan Neely down in that chokehold. It depends how you define it, until the threat abated. And was it too long? That was the question for the jury. And the jury ultimately said, if it's too long or not, we can't make a clear delineation beyond a reasonable doubt, and so therefore not guilty.
After the jury said they were deadlocked on the top charge, the judge granted the prosecution's motion to drop that charge and allow the jury to deliberate on the lesser included charge of criminally negligent homicide. The defense had asked for a mistrial, saying this could lead to a compromise verdict. Do you think the judge should have declared a mistrial?
No, because it is the prerogative of prosecutors to seek a verdict on the lesser counts. And just because you can't come up with a verdict on the biggest count, manslaughter in this case, doesn't mean that you can't look to, door B, because prosecutors wanted any type of conviction in this case. And quite frankly, I think this case probably should not have been brought, because I think going into it, prosecutors had to know it was very unlikely that they would get a conviction beyond a reasonable doubt. After all, jurors take the subway too, and all of us have had experiences with someone with untreated mental illness scaring people on the subway. So I thought this was an uphill battle, but I do say that the prosecutors should have been able to seek a verdict on the lesser charge, and they were.
I wasn't surprised when the jury said they were deadlocked, but here's what did surprise me. The jury deliberates for 4 days on the manslaughter charge, the top charge, and there are one or more holdouts. They can't reach a verdict, which of course has to be unanimous. They come back on Monday and start deliberating the lesser charge. And in 1 hour, they reach a not guilty verdict. What happened to the holdouts?
June, you hit the nail on the head. This was the biggest head scratcher, because they took a while hand-wringing over the largest charge, the most difficult charge, the manslaughter charge. And after there were holdouts and they couldn't come to a verdict, you would think that they would then deliberate just as extensively with just as many holdouts on the lesser charge. I mean, the lesser charge is much easier to convict Penny on, but yet they acquitted him on that one very quickly. And I think the reason is juror fatigue. Juror fatigue is a real thing. They had the weekend to think about it. They came back, and the holdouts, the ones who could not acquit Daniel Penny on the biggest charge, manslaughter, decided it wasn't worth the fight anymore, and let's just let him go.
I understand that when the judge told the jurors on Friday, you're going to come back on Monday and start deliberating on the lesser charge, one of the jurors was shaking his head back and forth. I mean, what jury wants to come back after a weekend? That's why you have so many Friday verdicts. So, Dave, the defense did raise a lot of questions here about the cause of death, the medical examiner's report, etc. Do you think that's what convinced the jurors, or was it just the fact that you have this guy who started out with good intentions? Even the prosecutor admitted that, and things got away from him.
Even the prosecution said that Daniel Penny acted with the right mindset. He was acting in self-defense. This was not a murder case. This was a case that at some point, when perhaps Jordan Neely stopped breathing, although that was a big bone of contention when that happened, or perhaps when the subway cars opened at the station, that Daniel Penny had an obligation to release the chokehold, and that's where he crossed the line. But see, that's a very difficult question for jurors, is to make that distinction between heroism and being a killer. And so it's tough for jurors beyond a reasonable doubt to find that delineation. And I think that's why this case was always going to be an uphill battle for prosecutors, because no one doubted that Jordan was threatening people on the train, scared people. Even the witnesses for the prosecution said, yeah, we were scared by him. The question is, at what point do you cross the line and go too far? And to ask a jury to find beyond a reasonable doubt that someone went too far is so hard when they probably have taken the subways, when they have been scared themselves, and when they probably wish at some point in their life that a Daniel Penny had stood up to protect them.
The legal system is not done with Penny. Jordan Neely's father is suing him for causing Neely's death through negligence, carelessness, and recklessness. Of course, the burden of proof is much lower in a civil case, and only 5 out of 6 jurors have to agree on a verdict.
Well, it's a much easier case than civil court because the civil standard is not beyond a reasonable doubt. It's by a preponderance of the evidence. Is it more likely than not that this occurred? And so, yes, it is a much better case against Daniel Penny civilly than criminally. I'm not surprised it is brought. It is one way for the family of Jordan Neely to obtain a measure of justice in their eyes. I don't know which way it will go, but definitely has a better chance. Now, if Daniel Penny had been convicted, then that lawsuit would have been much, much easier because once you've been proven beyond a reasonable doubt of acting carelessly or recklessly, then that comes into play in the civil court, and you're almost certain of winning a civil judgment.
As you know, Dave, there was a lot of pressure on Manhattan DA Alvin Bragg to bring charges against Penny. And his defense lawyers are considering bringing a malicious prosecution case against the DA. They say the DA blurred the ethical lines in handling the case and colluded with the medical examiner's office. How tough are malicious prosecution cases to win?
Oh, those are very hard. I mean, you really have to prove some bad faith, and that hardly ever works. In this case, if the DA was motivated by political pressure, that's still not malicious prosecution as long as you have the evidence. And as I said, there was enough evidence here, at least to file the charge, at least to seek an indictment. And yes, you could have been convicted of one of these charges, maybe just a lesser charge based on the evidence. But because of the lived experiences of the jurors, I thought that that would never happen. And so, both sides can be right about this. The defense can be right that this case should never have been brought. At the same time, the prosecution can be right that there was enough evidence to bring the case. Both sides can be true on this one. So this was a sign of the times. This case reflected a larger split amongst the public about issues of crime and race and homelessness and mental illness. And in the end, because there was such a split, because there was such a controversy, you were never going to get a unanimous jury, a 12-person jury, to decide beyond a reasonable doubt that Daniel Penny committed manslaughter. Maybe a lesser crime, possibly, but even that was too high of a burden for this jury.
The Manhattan DA is involved in another case that seems to have captured the attention of the public, the shooting of United Healthcare CEO Brian Thompson on a New York City street on December 24th. 26-year-old Luigi Mangione has been charged with second-degree murder, and DA Bragg has said he finds the public's fascination with Mangione disturbing.
Celebrating murder is abhorrent. For me, I've sit across the table from families who've had a loved one killed, and to think of people celebrating that.
Mangione was arrested in Pennsylvania, and he's fighting extradition to New York. But it's going to happen, isn't it?
It's inevitable. They're just forestalling the obvious. And there have been a lot of theories out there. Maybe one reason is he wants to avoid Rikers prison as long as possible, but he's going to get there. Or perhaps they want to force prosecutors to give up extra evidence that they wouldn't be entitled to otherwise at a hearing in Pennsylvania. But really, extradition hearings are so easy. The only main argument is this the guy who is described in the probable cause affidavit? Do you have the right person, or is it mistaken identity? Well, it's clearly not mistaken identity. So this is going to happen. He's going to be extradited. They're just delaying the inevitable.
There seems to be a lot of evidence against him already. They reportedly have ballistics from the gun he was carrying that match shell casings found at the scene. They have his manifesto, which speaks to his motive. It's early, but do you see any defenses here?
I think the only real defense would be that Mangione acted with severe emotional disturbance, that he was so upset about the way the insurance companies treated him and his family that this could be a manslaughter case and not a murder case. Now, I would disagree with that. I think this is clear murder. I think it should be premeditated murder, but that to me would be the best defense, to try to get a conviction on a lesser count that will allow him to get out of prison one day. Now, as far as another potential defense, there's what you call jury nullification. Jury nullification is when the jurors hear the evidence and see the law and disregard it. Instead of doing what they're told by the judge, they go their own way because they have sympathy for the defendant. They're not supposed to do it, but it happens. It's a prosecutor's worst nightmare. That is a possibility in a case like this, where there's so many emotions about it and so many hard feelings and frustrations towards the insurance industry.
If the jury is anything like the internet, it seems like jury nullification is a possibility, because The internet has exploded with all kinds of support for him.
And as a prosecutor, it's disappointing, and it shows you this is an age we're living in, the age of impunity, where you can say what you want, you can do what you want, and nothing sticks to you. You can get elected no matter what your past. You can be appointed no matter what you've done. And it's a reflection of where we are, where people are treating this guy as a hero when it's not a very courageous thing to put on a mask, lie in wait for an unarmed man, and then shoot him in the back and then run away. Not exactly Captain Courage. So he's not someone who should be raised up and lionized.
We'll see if the internet loses its fascination with him once more details come out. Thanks for your insights, Dave. That's Palm Beach County State Attorney Dave Ehrenberg.
The board was not heedless of environmental effects here. It consulted with dozens of agencies, considered every proximate effect, and ordered 91 mitigation measures. 88 miles of track should not require more than 3,600 pages of environmental analysis.
Former U.S. Solicitor General Paul Clement argued that federal regulators had done enough in considering the environmental impact of a proposed 88-mile railway in Utah. Under the National Environmental Policy Act, or NEPA, regulators are required to analyze the reasonably foreseeable environmental impacts before approving infrastructure projects. But justices across the ideological spectrum struggled with the test for determining when upstream and downstream effects should be considered in environmental impact studies.
Here's this 88 miles of line, and railroads are going to cross it, and wildfires are going to start as a result. Is that within time and space?
But how far downline or upstream or downstream should you look?
I mean, what are you going to do? You're going to say, okay, I've identified this possible issue, but I think it's too far away.
Most environmental effects, like effects on wetlands, are going to be sometimes remote in time and geography.
And Clement did admit that his proposed test wasn't an easy one.
If I could give you a 10-word test that took care of every hard case, I mean, they'd give me tenure at Harvard. But I think, having
I'm sure they'd give you that anyway.
That last comment coming from Justice Elena Kagan, who was once the dean of Harvard Law School. Joining me is an expert in environmental law, Pat Parento, a professor at the Vermont Law and Graduate School. Pat, first tell us about the environmental concerns here.
So this case involves a proposed 88-mile rail link in the Uinta Basin of Utah, which is huge. In fact, it's as big as Maryland. And it's loaded with all kinds of fossil fuels, including what's called waxy crude oil. I hadn't heard about that term before, but that's the product that they want to ship on this rail line. And the Surface Transportation Board, which is a federal agency within the Department of Transportation, has the authority to license or approve construction of this link, which will take the oil from the Uinta Basin east and connect it with the national railroad network and take it all the way to the Gulf Coast, where it will be refined into various products. So the concerns here are the drilling and the extraction that's going to occur as a result of providing this critical link. Without this railroad, this oil reserve couldn't be exploited. So it is a major resource with economic value and some jobs, undoubtedly, and income to Utah and the county. The Ute tribe of Indians is involved in this, and they have concerns about the drilling, which will potentially impact some of their resources. And there's concerns about spills, which are inevitable when you're moving oil by rail. There's always either chronic, low-level spills, leakages, or in some cases, of course, worse than that, derailments, and we've seen that. But then, of course, downstream, there's concerns about burning all of this oil, and the impacts on climate change, but also impacts on the communities around the refineries in the Gulf Coast, Port Arthur, Texas being a primary focus of this. So a variety of environmental issues typical of a major infrastructure project like this.
And tell us about the legal issue around the environmental impact study for this railway.
So this has to do with the scope of the environmental impact statement that the Surface Transportation Board prepared for this project. And actually, STB, as it's called, did, what you might consider a pretty thorough job. I mean, it amounts to literally thousands of pages of analysis when you look at the whole administrative record. And they did look at these upstream impacts of drilling and the downstream impacts of potential spills in the refinery, but they only did so to, a certain level. And the D.C. Circuit, when this came to the D.C. Circuit for review, said, STB, you did an okay job, but not good enough. You needed to delve more deeply into these upstream, downstream issues than you did. So what it comes down to is how much analysis does NEPA require when you have an 88-mile project that is approved by this agency, the STB, and how far beyond the footprint, if you will, of the project does NEPA require you to go when you're analyzing these more remote in time and distance problems? And that was the focus of the argument before the Supreme Court.
Was there an answer to what kind of test would work here? I mean, did anyone have that answer?
Yes, Paul Clement, who's the former Solicitor General of the United States for a while, so he's a very accomplished, seasoned Supreme Court litigator, and frankly did a terrific job representing his clients, of course, who want to develop these oil reserves. And his test, which he offered and explained over and over again to the court, he was up there for almost an hour being questioned by almost everybody on the bench. And his test was the following. Number one, you do take into account how remote in time and space are the impacts that you're talking about, number one. And number two, how many of those impacts are actually within the jurisdiction and authority of the agency in question, namely STB? His answer to both of those was, A, the impacts, particularly the refinery impacts, which are 500 miles away or more, are way too remote in time and distance and speculative in terms of what will actually happen and so forth. And they're subject to other agencies' jurisdiction, either state agencies or federal agencies. There's another agency that's involved with rail safety, for example. So when you talk about the condition of the tracks and whether there's the potential for spills, his argument is that's another agency's problem. That's not STB's concern. And refinery operations, that's subject to Texas state regulations for whatever that's worth, as well as, EPA and other agencies. So on his remote in time and space argument, he said these impacts that the D.C. Circuit found fault with are not required by NEPA. And number two, he said, when you have these other agencies with responsibilities and STB does not have any authority to control these impacts, then NEPA doesn't require STB to have to analyze them. What's the point, he said, of analyzing all this to the nth degree when they can't do anything about it? And so that was his argument.
Did the challengers have a test?
Yeah, so the challengers said, well, first of all, NEPA has always required consideration of indirect effects. And these are foreseeable indirect effects. And there really wasn't a whole lot of argument. Even Clement conceded these are foreseeable impacts. They may be difficult to quantify, although the environmental advocates said they weren't difficult to quantify. I mean, you know how much oil is going to be extracted, and from that you can begin to calculate how much will be refined and what kind of spills might happen and so forth. The environmental groups challenging this project, I thought, were able to say, look, what we're asking for here is not that unreasonable. It's not that different from what courts have required in the past. And it should still be the test here that, when the agency undertakes to do an analysis, it needs to do it right.
But did it seem like justices across the ideological spectrum had problems with the environmentalist position?
Here's what I would say as the bottom line. There's no support on the bench, either liberals or conservatives, to uphold the D.C. Circuit. That was clear. The liberal wing of the bench asked as many difficult questions of an environmental advocate as did the conservative justices, in some cases even more aggressive, right? So they were clearly signaling they were not going to be upholding the D.C. Circuit. And my reading is what they were really signaling to the rest of the conservative colleagues on the bench was, let's see if we can find a basis to overturn the D.C. Circuit's decision and allow this project to proceed that doesn't do any more damage to the NEPA process than, quote, is necessary to decide this case. So that's what I'm going to be looking for, not what the outcome is. The outcome's clear. You know, NEPA has been in front of the Supreme Court 15 different times and has lost every single time. This will make the 16th time that NEPA will have lost in the Supreme Court. That seems foreordained to me. But the real question is, how broadly is the court going to go in limiting the scope of NEPA analysis in a variety of other cases? This is just, one 88-mile rail line, right? But NEPA applies to a huge number of federal actions, of course. So that's what I'm going to be looking for. Will they write a narrow opinion, overturn the D.C. Circuit, let this project be finished, and leave the rest of it alone?
Pat, I want you to listen to what Justice Brett Kavanaugh said about deference to agencies being important here.
It seems to me the deference of the courts has to be huge with respect to how the agencies think about the scope of what they're going to consider. And it seems to me the problem that has crept in is conflating what the agency can do and should do from what the role of the courts is here. And by the courts taking an overly aggressive role.
Correct me if I'm wrong, but wasn't Kavanaugh in the majority when the court threw out the Chevron doctrine and deference to agencies' interpretations of ambiguous statutes?
Well, the old saying, consistency is the hobgoblin of small minds. So, yeah, there's a little bit of inconsistency there, right? So we will defer to agencies when we like what they're doing, but not defer to them when we don't. I'm not going to go completely cynical on that, although I'm tempted. But certainly there's tension here between when you're going to give an agency deference and when you're not. This is a gray area of NEPA law, I have to say. And, reasonable people, I suppose, can disagree about how far you should go.
And we'll find out by June just how far the court goes with respect to NEPA. Thanks so much, Pat. That's Professor Pat Parento of the Vermont Law and Graduate School.
And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.